Okay, it looks like we've reached critical mass here. Good morning. It's May 16th, 2025, and I'm Sam Bibbins, the hearing officer for the Administrative Hearings Office of the State Water Resources Control Board, been assigned to this matter. This is a pre-hearing conference on the pending petition for long-term transfer filed by Yuba County Water Agency for permit 15026, application 5632. This pre-hearing conference is being conducted by Zoom webinar and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom-generated transcript to the administrative record that is available on the board's FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you experience technical difficulties trying to communicate with us, please send an email to the AHO at admin.hrgoffice@waterboards.ca.gov. AHO staff will be monitoring the email inbox, and I have several staff of the AHO assisting me today. Nicole Mullen, Sam Bullen Bryan, Skylar Anderson, Kyle Wooldridge, and Rebecca Stolfus. If at any time I experience technical difficulties during this conference and I'm unable to rejoin, within a few minutes, one of the AHO staff will call a recess until I'm able to rejoin you. With that, I'd like to move to appearances. We're using Zoom webinar for security purposes, so this may be a little bit different for those of you who've practiced before our office in previous years. As I call on each of the parties, I ask that each party's lead representative raise their hand on the Zoom application. And then my staff will promote those individuals to panelist status, which will allow you to talk and appear on camera and so on and so forth. Once you've been promoted to panelist, please state your appearance and identify any other individuals from your team who you expect to have a speaking role during this conference. And as we proceed, please keep your microphone muted except when you're speaking so that we can minimize background noise. So with that, appearances for Yuba County Water Agency, please. I see Mr. Becerra has raised his hand.
Good morning, Mr. Hearing Officer. Ryan Becerra, attorney for petitioner Yuba County Water Agency.
Thank you. Good morning, Mr. Becerra.
Good morning.
California Sport Fishing Protection Alliance. I see Mr. Schutz has raised his hand.
Good morning, Hearing Officer Bivens. It's Chris Schutz with the California Sport Fishing Protection Alliance.
Good morning, Mr. Schutz. Thank you. South Yuba River Citizens League. See Mr. Zettler Mann has raised his hand.
Ooh, move my camera up. Aaron Zettler Mann, Executive Director of South Yuba River Citizens League.
Good morning, Mr. Zettler Mann. Friends of the River. I see Ms. Mertz has raised her hand.
Good morning, Hearing Officer Bivens. Keiko Mertz appearing on behalf of Friends of the River.
Good morning, Ms. Mertz. American Rivers. All right, one more time. Is anyone here for American Rivers? All right. See, oh, Mr. Schutz, do you have? Are you here for American Rivers?
I'll be glad to at least keep Ms. Quinn informed of what's going on here. I was not aware she wasn't able to attend today, but apparently she's not.
Thank you, Mr. Schutz. Let's see, Northern California Council of Fly Fishers International.
and I believe Mr. Rockwell is out of town, so I can also keep him informed.
Thank you, Mr. Schutz, for keeping them informed and for keeping me informed as well this morning. Sierra Club Motherlode chapter. I see Mr. Worth has raised his hand.
Good morning, Sean Worth, representing the Motherlode chapter of the Sierra Club.
Good morning, Mr. Worth. Richard Murat. I do not see Mr. Murat on the screen. Tell me, Mr. Schutz, since you seem to be the coordinator amongst protestants in a lot of these proceedings, have you been in any communication with Mr. Murat?
I have not.
Okay, thank you. I was hoping I would get a chance to speak with him today. Nevada Irrigation District. And I see Mr. McClure has raised his hand.
Good morning, Andrew McClure for Nevada Irrigation District.
Good morning, Mr. McClure. And then South Delta Water Agency, Central Delta Water Agency, and Rudy Musi Investments LP, who I'm going to collectively refer to as the Delta parties. And I see Mr. Ruiz has raised his hand.
Good morning, Dean Reese on behalf of Central Delta Water Agency, South Delta Water Agency, and Rudy Musi Investment LP.
Good morning, Mr. Reese.
Morning.
And then we have a number of other folks who are in the attendees box of my participant list. Have I missed any parties to this proceeding? Mr. Soderlund, Ms. Harms have both raised their hands. Let's go ahead and promote them and let them make an appearance.
Morning, Eric Soderlund on behalf of the California Department of Water Resources.
Good morning, Mr.
Filed
Soderlund.
a request to be a party to this hearing. So I'll just leave it at that and then see where we're at with that.
All right, very good. I will say that I was on paternity leave for a while until about a week ago. So if you, I may have missed that, and we will look into that and do with it what we need to do with it. So thank you for alerting me to that. And Ms. Harms, I saw you for a moment.
Yeah, good morning. Rebecca Harms on behalf of the San Luis and Delta Mendota Water Authority. And we have been granted party status in this hearing.
Very good. We will make sure my list is updated. Thank you. All right. There are still 3 folks left, so unless one of them raises their hand and wants to make an appearance, I will assume that they are listening in today.
Mr. Bivens, if I might, believe that let's see, San Luis and Delta Mendota filed a notice of intent. DWR filed a notice of intent. State water contractors also filed a notice of intent.
Aha, and that would explain Ms. Johnson. I know she typically represents state water contractors. Thank you. Let's promote Ms. Johnson, please. Good morning, Ms. Johnson. You want to go ahead and make an appearance for, I assume, state water contractors?
This is Natalie Reed. Jenna Mandel-Rice would appear for state water contractors, but she's having some trouble connecting. So I'll go ahead and appear for state water contractors.
Very good. Thank you. All right. So let's thank you for bearing with the slightly longer appearance process that's associated with this Zoom webinar application. Let's get into the agenda for today. And my agenda is pretty straightforward. I'd like to address a few procedural issues, and then get into Yuba Water's motions to cancel protests. So we'll start with the procedural issues. And I understand the parties have agreed to opening statements of up to 10 minutes and up to 20 minutes of witness summaries per witness, which all sounds great. And I also understood from Mr. Becerra's email that the parties plan to meet and confer about cross-examination time limits after testimony is submitted, which is totally understandable. So we'll look forward to that. Just to facilitate that meet and confer process, I'll tell you what the default rule will be if you don't figure it out amongst yourselves. And maybe that will help kind of narrow the issues. So essentially what I would do is impose if left to my own devices, I'd impose a chess clock approach. And I'd basically just make an assumption about how many hours of hearing time we'll have and divide it up amongst the parties, depending on the number of witnesses and the issues and the relative importance of the witness testimony when I review it. And whatever I determine to be an appropriate allocation of time is the amount of time that each party will get to do everything. And that includes opening statements, direct exam or witness summaries, cross-examinations, and objections. So basically, if you're talking, you're running the clock on your allocation. And I tend to think that system works pretty well. It gives attorneys some flexibility, particularly when there are witnesses who are more challenging on cross-examination than one might have expected. But invariably, when we've imposed those allocations, we hear from parties who think they deserve more time. They send me something to that effect, and other parties object. I have to write something, and I'm typically going to decline to change the allocations, and no one is particularly happy. So it's really much better if you guys can agree on time limits that will get this done within the scheduled amount of time. So as you're negotiating amongst yourselves, just keep that kind of background rule in mind. And then actually, as long as we're talking about this, a quick word about objections. So my experience in these proceedings is that the lawyers tend to give much longer objections than they'd ever try in a courtroom. And lest anyone think I'm casting aspersions on any particular individuals, guilty. I did the same thing. People try to get away with what they can get away with. So I'll just tell you now, when we go to hearing, I'm not going to allow speaking objections. Your objection should be brief. I'll rule quickly and we'll move on quickly. And there really shouldn't be any argument unless I ask for it. And frankly, if you have to make a lengthy argument on a evidentiary objection in a hearing, it's probably not a very good objection. So let's keep that in mind. All right. Any questions about timing, time limits? Anything folks want to address about that? Mr. Schutz.
Yes, Hearing Officer Bivens. I didn't quite understand your position on spoken objections. I thought I understood you to say you weren't going to allow them, but then you discussed how long they could be. So could you refresh my understanding?
And I forget that some of you are not lawyers, despite your capable appearances in these types of proceedings. So, Mr. Schutz, a speaking objection is an objection where you give a fair amount of argument about why the objection should be granted, and a more typical objection would be objection relevance, objection calls for speculation. I want them limited to those kinds of very brief, like I object, and here's a brief statement of the ground, and then I will rule. But I don't need you to tell me, for example, this question calls for speculation because blah 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 blah. I don't need any of that. I think I can rule pretty quickly on those.
Thank you for the clarification.
Thank you, Mr. Schutz. All right, with that, let's get into the motions. So I'm going to have a question or two for NID and the Delta parties about their procedural arguments, and then I think what I'll do is give an oral tentative ruling on the substance of Yuba Water's motions. And then once I've done that, I'll give each group of parties, starting with Yuba Water, up to 10 minutes to address whatever they want to address. And Yuba Water can reserve some time for reply if they wish, and we'll have the last word unless I change my mind and ask for a brief response from someone else. Once we're done with that, I will take the matter under submission, and we'll get a ruling letter out as fast as I possibly can. I know this is potentially germane to the witnesses you all put on, and you're probably working pretty hard on that. So my goal is to get that ruling letter out before June 11th, and hopefully within in that first week of June. But I'm committed to getting it to you all with enough time to make decisions to the extent decisions need to be made. So with that, procedural question for NID and the Delta parties. You both have argued that the AHO can't dismiss a protest without giving the protestant an opportunity to provide more information to explain or substantiate the protest. But here in these motions, I understand Yuba Water to be essentially arguing that because those protests are deficient as a matter of law, there's really no additional information that could substantiate or support the protests. And so my question is, how do NID and the Delta parties think the AHO and the state board can address protests that may be deficient as a matter of law? And I don't think it's going to be particularly satisfying to hear that I have to hold a hearing on legal arguments that, you know, potentially could not result in a favorable decision to the protestants advancing them. That's not workable. So perhaps Mr. McClure, I will start with you. What can I do with legally deficient protests?
Thank you, hearing officer. I think this really has to do with the sequencing of how the state board and hearing office deals with protests. And of course, there's an application and a protest, and under 1703.1 through 1703.6, upon receipt of the protest, that's the time for the board to request additional information if necessary to understand the basis of the protest or to understand whether it asserts a cognizable protest. In this case, that occurred. That did not, I mean, that time passed without the state board requesting any additional information. So once that window closed and the matter was referred by the executive director to the hearing office without any additional request for information, and the hearing officer then identified issues for hearing, set an adjudicative hearing, we are now have facts that need to be proven in that hearing. The time for any additional information to simply understand the protest has already passed. So that is the basis of NID's procedural argument, is that yes, under those statutes, the state board has an opportunity to request additional information if it needs that to simply understand the protest. Here, that window passed, no questions were asked, no additional information was provided because none was requested. And so now, on the precipice of a hearing, it would be inappropriate to dismiss the protest on the basis that we didn't provide any additional information that was never requested.
Okay, and so understood, Mr. McClure, but I guess my understanding of Yuba Water's argument, and you know, specifically to NID's position, is that there's no information that could substantiate at least the water right injury portion of your protest. So is it your position that the AHO can never take a look at the legal sufficiency of a protest once, say, Division of Water Rights staff have accepted it?
Under the statute, yes.
All right. Mr. Ruiz, do you have anything to add to Mr. McClure's argument?
Good morning again. I would echo Mr. McClure's arguments. We take the same position and feel that's the correct position. Had there been deficiencies or supposed deficiencies in the protest, the time to identify those has passed. And so I think that's clear under the statute. There was no indication there was deficiencies, and the abundance of caution. We provided additional information in our opposition papers with regard to the allegations and the information with regard to the water right holders. But again, I think the time for that has passed. With respect to your question, you know, could somebody like Yuba ever, make a motion as a matter of law? I don't think so under the statute. They certainly would be free to make some sort of a summary motion, after a protestant's case in chief. But at this point, I think that opportunity has passed.
You both have mentioned this time window, and I'll confess I've had a lot of Westlaw tabs open as I think about these motions and the responses. Where do I find the time limit in the statutes for that effectively closes the window for anybody to think about legal arguments associated with sufficiency of the motion?
Well, it's 1703.1 through 1703.6, and there are a number of opportunities there for the state board to request additional information, to reject a protest because it's not submitted timely. Basically, this is the opportunity for the state board to ferret out protests that are unmeritorious because they're untimely. Alternatively, if the state needs additional information to understand the protest, that's the opportunity to request that information. So there's a gatekeeping function that's contemplated by the code, and that is upon receipt of the protest. Here, obviously, the state board received the protest, set a opportunity for meeting and conferring answers to protest.
Mr. McClure,
Yeah.
McClure, where's the specific window in the statute? Where's the specific deadline that says I can't look at this again?
Let me pull 1703.1 and 1703.6. But while I'm doing that, I would also like you to refer to the procedural history of this case and the numerous memorandum and notices and assignments, each of which do authorize rejection of a protest under those water code statutes, but direct the hearing officer to conduct an adjudicative hearing. So again, the gatekeeper is the state board. And in this instance, in its assignment, directed the hearing officer to conduct a hearing. So now let me turn to 1703.1. Through 6. So again, these are gatekeeping functions. There are certain requirements that a protest has to meet. 1703.3, board may request additional information and provide a reasonable time for submitting the information. Here, that request never occurred. 1703.4, resolution of protests. That's the 180-day period that occurred in this case. And again, no additional requests for information from the board. 1703.5, another opportunity for additional information, a reasonable period for submitting the information, additional time for good cause shown. So all of this contemplates a request for information to understand the protest and an opportunity to respond. If the protestant does not respond within that reasonable period of time, then the protest can be rejected. In this case, that never occurred.
Mr. Reed, do you have anything to add about where I can find a specific time limitation on the board's ability to reject a protest?
I think it's in the statutes, the sections that Mr. McClure just referred to, particularly 1703.4 with regard to the 180 days and 1703.5. It appears pretty clear that as long as there's reasonable information provided, the board could have requested additional information if thought it was necessary, such that the parties would have an opportunity with enough information to potentially resolve the matter, resolve the protest. But that's not that hasn't happened here. There hasn't been a request for additional information, and I think we're at the point where we're ready to proceed with a hearing on the merits.
And Mr. Ruiz, this just directed at you. I authorized Yuba Water to file these motions and set a briefing schedule that gave you an opportunity to respond to the arguments. Excuse me, I have another spam call that needs to be rejected. Thank you. And in fact, the Delta parties did submit additional information about the water rights they're representing in this matter. So, I mean, wasn't the opportunity to respond to Yuba Water's motions that opportunity to provide additional information to substantiate the protest?
Was that an opportunity? I'm sorry, some of that was broken up. What was the last part you said?
Yeah, wasn't the opportunity to respond to the motions that I authorized and set a briefing schedule for? Wasn't that an opportunity to provide more information to substantiate the protest and respond to Yuba Water's legal arguments?
Yeah, it was, and we did so in our opposition. Yes.
Very good. Mr. Becerra, I will turn to you if you'd like to respond to any of those procedural issues.
Yes, thank you very much. I don't think it's this complicated. The state board has mandatory regulations for what a protest needs to say. The protestants need to comply with the regulations. I don't think the code anticipates, certainly the regs don't anticipate that you can file whatever you like as a protest and then rely on the state board to have to ask for more information from you. And then if they don't, you just get to go to a hearing. Certainly, I don't believe there's any state board order precedent for that. The 1989 order that we cited in our reply to the Central and South Delta opposition to our motion was pretty clear about that a shotgun approach of filing protests is not adequate. You need to comply with the regulations. That did not occur here. In the instance of these two protests, there is a clear legal inadequacy of both protests. The NID protest is based entirely on upstream water rights. Under Section 749 of the board's regulations, that's not adequate. As to the Central and South Delta protest, it is apparently a citation of all of the water rights in the Delta with no individual water right holder actually providing the information required by 745 of the state board's regulations. I don't believe any of the code sections cited mandate that a protest must go to a hearing if the board doesn't ask for further information. Again, it's the protestant's obligation to file an adequate protest. And I think the hearing officer under the Water Code 1112C has the authority to dispose of the matters in this hearing. And certainly the assignment from the Division of Water Rights authorizes the hearing officer and the AHO to resolve the protests. That to me indicates that cancellation of them is authorized. So I believe that in this case, both of those protests have a clear legal inadequacy and should be canceled.
All right, thank you. I think I've heard enough about the procedural aspects of those motions. Let's move on to the substance here. So just some brief thoughts about the legal standard. There are requirements for protests that are identified in the relevant statutes and interpreting regulations of the State Water Board. But when I'm just kind of conceptually thinking about how to make a decision on these motions, I'm thinking of it sort of like a pleadings motion in civil litigation, where if we accept all the factual assertions in the protest as true, do they still fail as a matter of law? Or alternatively, are there insufficient factual allegations in the protest to substantiate them under the governing statutes and regulations? And in that instance, I would probably say it would be prudent to in the latter instance, it would be prudent to, as courts typically do, allow some leave to amend the protests, depending on what information may or may not be available. So that's just kind of how a preamble as to how I'm thinking about how these motions ought to be decided. So to get into the substance, I'll start with my tentative ruling for the Delta parties. My intention is to deny the motion with respect to the Delta parties. I generally agree that the Delta parties are not entitled to releases of stored water from upstream reservoirs, and that Delta water users are not entitled to divert and use transferred water release from storage. I also generally agree that the Delta Party's protest should have included information about the water rights they're representing in this hearing in the first instance. That said, I think the informational problem has, in my view, been cured by Exhibit B to the Delta Party submission. There's enough identifying information in there, I think, for Yuba Water to take a look at the underlying water rights and to the extent and water right claims, and to the extent they want to make arguments about individual water rights not being injured by the approval of the petition as currently presented. They have enough there between the ERIM site and potential discovery options to do that. I can't imagine there would be a whole lot of appetite to treat the thousands of water users identified in Exhibit B individually. It seems like the Delta parties, have arguments, appropriately have arguments common to their representation of all those water users. But I will leave it to Yuba Water Agency to decide how they want to litigate their case. On the injury claims, after reviewing the Delta Party's protests, I find that the protest based on injury does not depend upon a demand for reservoir releases or stored transfer water. That protest seems to have concerns about how the terms and conditions under which New Bullard's Bar will be refilled, the stream flow depletion factor applied to the groundwater substitution portion of the proposed transfer, and the carriage water requirement for the transfer, all of which they allege protect the state and federal governments, but not necessarily their constituents. And those arguments seem like fair game for a water right hearing. They also have arguments and allegations about how D1641 requirements have failed to protect Delta right holders and how export operations affect the ability of those right holders to divert based on both water levels and water quality. And those seem like fair game for a water right hearing to me too. So my tentative ruling will be to deny the motion to cancel the Delta Party's protest. I've reached the same conclusion with respect to the NGO's protest, and candidly, I'm still working through this one. My general sense is that these environmental impact and public interest protests are just frankly less amenable to dismissal based on legal arguments or arguments that as a matter of law, they can't proceed. I'm willing to be persuaded, but I don't see that here. The NGOs have arguments that any protections provided by D1641 have been undermined by approval of GUCPs in dry years, such that stricter permit terms are required. Certainly there have been a number of GUCPs granted over the years, and that seems like potentially important context to understanding what types of terms and conditions might need to be imposed on the petition if it's ultimately approved. They also argue that Yuba's storage of water in the spring for late summer transfers deprives Salmonid of needed flows, and allege that the Yuba Accord has generally not improved conditions for salmon thus far, and that more water is generally needed for fishery resources in the Delta, and that also seems like fair game for a water right hearing. And then finally, they have some arguments germane to the State Water Board's exercise of discretion in approving the petition as a matter of public interest. And I frankly don't see a world in which it's appropriate to preclude them from making those kinds of generalized public interest arguments. There seems to be at least the level of factual support necessary to get to a hearing. So my tentative ruling is to deny that motion. With respect to Richard Murat, I'm inclined to cancel his protest based on his failure to file an NOI, his failure to oppose the motion, and then in the protest itself, a general failure to connect his arguments to the terms and conditions of the petition. I don't think personal observations from 1992 are going to be enough to substantiate a protest under Water Code Section 1703.2 Subdivision C and Section 745C of the board's regulations. And I was hoping, frankly, that we would get Mr. Murat here to talk about his protest. I know he did send an email to someone with the Division of Water Rights staff generally objecting to the cancellation of his protest, although it was not sent to the AHO directly. So in any event, I was hoping to hear from him, but he's not here, and I think that council's in favor of canceling that protest as well. All right, and then finally, we get to NID, and I will say that I agree that to the extent NID's injury theory is based on Yuba Water's request to FERC in a relicensing proceeding, that it fails to state a valid ground of protest. The general rule under Section 749 of the board's regulations is that a protest based on interference with the prior right of an upstream user will normally not be accepted. NID seems to argue that the general rule doesn't apply to its injury claim because in a separate FERC relicensing proceeding, Yuba Water is asking NID and PG&E to release more water from their upstream reservoirs. And so NID argues that if that request is granted, Yuba will then be able to transfer that water if the long-term petition is approved. And my tentative finding is that any harm to NID associated with the possibility of FERC granting Yuba Water's request does not state a valid ground of protest. That FERC relicensing proceeding is entirely separate from this proceeding, and it looks to me like FERC could grant Yuba's request even if the state board ultimately denies the pending petition. So, you know, NID seems like it could potentially lose out on that 15,700 acre feet of water, regardless of the decision that I make or the decisions the state water board makes. And then further, based on Yuba Water's own proposed terms in the petition, it would be precluded from transferring the additional releases that may or may not be required by FERC to protect listed species in the lower Yuba River. And I didn't see anything in NID's opposition that disputes Yuba Water's construction of the scheduling and accounting principles in its proposed term. So if Yuba's request to FERC could be granted regardless of how the state water board acts on the pending petition, and Yuba Water could not transfer additional water released by NID under a potential FERC decision, then I don't see how approval of the pending petition could injure NID's prior upstream rights. Now, that all of that said, I don't think it's appropriate to completely cancel NID's protest because NID also appears to have protested the petition based on public interest and environmental impact grounds. And I didn't see any arguments in Yuba Water's motion to suggest those aspects of NID's protest are invalid. So I don't believe I can completely cancel NID's protest. So my tentative solution for dealing with the injury component of NID's protest is to deal with it as an evidentiary matter. And I would find that evidence and arguments related to potential outcomes of the FERC proceeding is irrelevant to the board's decision, speculative, and would constitute an undue consumption of hearing time under Government Code Section 11513. And I would exclude any such evidence and argument from the hearing. So NID would remain a party. It would be free to continue to advance its environmental, jurisdictional, public interest grounds at the hearing, but evidence related to, potential, I don't think it's injury, but we'll call it potential injury associated with Yuba Water's request in a separate federal relicensing proceeding is not going to come into evidence. Okay, I talked a lot. That's basically where I'm at with the substance of the motions. Mr. Becerra, I will turn it over to you and give you up to 10 minutes to argue whatever you want to argue.
Thank you very much, Mr. Hearing Officer. Certainly appreciate the tentative on Mr. Murat's protest. I don't have anything further to say on that. Relative to Central and South Delta, and actually this applies to the NGOs and to NID as well. These protests don't actually deal with the pending petition. They all deal with other issues. The Central and South Delta protest is primarily about Delta conditions generally. Similarly, the NGOs protest is about Delta conditions generally for the most part. The NID protest is largely about the FERC relicensing. I honestly don't have a good sense as to what the public interest assertion is in the NID protest. So all of the protests essentially do not deal with the detailed terms that Yuba has proposed that effectively address all of the protestants' concerns. So simply the protests haven't provided sufficient information to demonstrate that there is adequate grounds for protest. So I think with that, obviously you've given this a fair amount of thought, so I'll leave it with that. There does not appear to be adequate grounds under the state board's regulations for any of the protests.
So just out of curiosity, Mr. Becerra, I mean, how much detail and engagement do you think are needed with specific terms and conditions for a protest to be sufficient? I mean, I've done some research. There's, as you probably know, there's not a whole lot of law or precedent on the level of specificity that a protest needs to include. What do you think the level of specificity needs to be?
I think the fundamental problem is both Yuba Water and the state board have done a very large amount of technical analyses in the Yuba, in the original 2007 Accord EIR, and then in the 2024 supplemental EIR for this petition, and the state board in its 2008 approval order of the initial transfers dealt with all of these issues in a very large amount of detail. And none of the protests engage with that at all. And they do not deal with the specific terms that Yuba has proposed the state board adopt in approving these transfers based on all of that technical detail. So the idea that we have protests that just essentially say, we think there would be problems without engaging with the actual real technical analyses that Yuba and the state board have done is problematic, because essentially that would authorize protestants to just not really engage with what an actual petition is. So it's not a matter of decided law, certainly, but we certainly have the principle in the water code that protests are supposed to engage with the underlying CEQA documents, or they are subject to being canceled, and none of these protests do that.
Thank you, Mr. Becerra. All right, Mr. Reese, I will turn to you next.
Thank you. I would just note, I wrote down what you indicated in your tentative ruling for the grounds for denying the motion to cancel, and I wouldn't. I agree with those, and those were right out of out of our opposition. And I would just indicate substantively that the arguments that Mr. Becerra makes with respect to most of the other, the EIR and some of the other aspects that Yuba's gone into detail with, if the protests in their case in chief are deficient, then that's an issue in terms of a case in chief, not an issue in terms of what needs to be in the protest. And we've gone through this, but what's required of a protest is pretty basic, and I think that information has been provided. I would just say on the substance, it's that we're not, Central and South are not arguing that they're entitled to Yuba's stored water. What they're arguing is that the proposed transfers could adversely impact the water quality and the water quantity within our area, within the Central and South portions of the legal delta. And that's particularly true for exports of the proposed transfers through DWR and USBR's export pumps in the South Delta. We're specifically challenging the adequacy of the measures Yuba Water intends to take to avoid those impacts, namely, the proposed refill agreement, the stream flow depletion factor, and carriage water obligation. And of course, we challenge the adequacy of relying on DWR and USBR's compliance with D1641. So those are what the heart of the substance of the protest, and that's what we'll have to deal with in our case in chief. And with that, I would submit.
Very good. Thank you, Mr. Reese. Mr. McClure.
Thank you, Hearing Officer Bivens. One issue that I do want to clarify is that another material part of NID's protest concerns the terms of a 1961 stipulation between NID and Yuba Water Agency, which was incorporated in the water right at issue, which provided that there would be no injury to NID's upstream water rights. And so if the state board does not have authority to enforce that provision in a subsequent proceeding, there's a real problem with how we're ever going to obtain an entity with jurisdiction to enforce that provision. And so I appreciate the hearing officer's ruling regarding speculative outcomes and other forums, but the terms of our 1961 stipulation, again, incorporated in Yuba's water right, should be open for evidentiary proceedings at the hearing. And that was identified in our protest. Yuba did not focus on that in its motion to cancel, so it was not a focus of our opposition. But to the extent the hearing officer is going to issue a ruling that would operate as some type of motion and eliminate and potentially exclude, presentation of evidence on issues, I want to make sure that we have the opportunity to present evidence concerning the terms of Yuba's water right, which should be absolutely fair game. Secondly, we have dealt with all of us probably in civil litigation, and I just want to make a point about the procedural issues here. What we're essentially having is some type of motion for summary judgment or a demurrer proceeding, and we should all have the opportunity to amend a protest if there is going to be a cancellation. I agree that there are what the law says under the Code of Civil Procedure regarding cancellation of or granting a demurrer without leave to amend. There's case law on that, but that case law has not made its way into the State Water Board. And so I would just, for whatever it's worth, on behalf of future protestants, request that if there is an intent to cancel a protest, that there be an opportunity to amend to address that issue. So setting aside that procedural footnote, with respect to the hearing officer's ruling on the motion, understood, subject to a request that be narrowly tailored in any letter ruling that the hearing officer issues to ancillary proceedings.
Fair enough, Mr. McClure. I don't intend to say anything about the stipulation in the ruling letter in terms of the evidentiary aspect of the ruling letter. I mean, that evidentiary ruling is going to be limited to these arguments on injury based on the FERC proceeding. But let me ask you this. I mean, the argument about the stipulation seems to me a little bit circular. I mean, if the stipulation says no injury, but the outcome of the FERC proceeding cannot, as a matter of law, at least in my view, result in injury, what extra juice does the stipulation give you?
If the order coming out of this proceeding says that Yuba shall comply with the stipulation and with the terms of its original water right, that would be an appropriate condition to include in the order.
I'm not sure I understand, but Mr. Becerra, is Yuba Water, does Yuba Water have, I guess, any objection to complying with the terms and conditions of its water right other than as modified by the pending petition?
No, Yuba Water intends to comply with the terms of its water right, and I agree that Mr. McClure's argument about the 1961 stipulation is circular. It is only allegedly relevant here because of the potential effect of the FERC proceeding on NID's operations. Again, FERC can do as it wishes in that proceeding. That is not relevant here. So the 1961 stipulation is also not relevant here. This is a proceeding on Yuba's petition for the one and only purpose of extending its long-term water transfers.
Okay. Mr. McClure, before I move to the NGOs, did you have anything else other than what we just talked about that you want to address?
No, thank you.
Thank you, Mr. McClure. All right, I'll move to the NGOs who I candidly don't expect to have much to say about this, but I'll start with you, Mr. Schutz. Do you have any arguments you'd like to make with respect to?
Thank you. I have a couple of things. One, just as a matter of factual background, part of the issue at play in the disagreement in the FERC proceeding between NID and Yuba Water Agency has to do with the appropriateness of asking NID, generally a senior water right holder, to contribute water for the benefit of arguably either fish downstream of Englebright Dam or for the benefit of Yuba Water Agency in order that it can meet its obligations downstream of Yuba, of Englebright Dam. And so there is some overlap and there is some question between, sort of how far FERC will go in ordering a resolution in the FERC proceeding based on its need to respect water rights under Section 27 of the Federal Power Act. As far as Mr. Becerra's discussion of the NGO's purported deficiencies, I agree with your ruling and thank you very much. I would point out that Mr. Becerra, in substantial part, is relying on documents from 2007, 2008, and conclusions that were drawn at that time that the subsequent 16, 17 years have shown some changes regarding. Whether or not Yuba's application and CEQA document fully answer the concerns that the NGOs have expressed, I think is a factual issue that is appropriately addressed at hearing, not simply something that can be resolved by an assertion by Mr. Becerra and his clients. So we look forward to the opportunity to resolve those specific issues. I will say that the protest of the NGOs is not a shotgun protest. It has to do with specific aspects of Yuba Water Agency's application and calls for specific and limited and targeted remedies. And in that sense, it's appropriate to address those at hearing.
Thank you, Mr. Schutz. Anyone else from the NGOs want to add to what Mr. Schutz has said? All right, hearing none, Mr. Becerra, I will give you the last brief word.
Thank you. 2 points in relation to the NGO's protest. Again, it simply doesn't even acknowledge the technical analysis Yuba has presented in this proceeding of Delta issues. Not only is there a supplemental EIR, which refreshed the 2007 EIR's analysis, but there is also a technical appendix to the petition itself on this exact issue of whether changed conditions in the Delta are relevant to this matter at all. And the NGOs simply do not engage with that technical analysis. And so simply saying we disagree and there are problems is not adequate to go to a hearing on. On second point about the NGOs, I would appreciate some clarity as to whether or not that protest concerns Yuba River conditions at all. Our initial response to that protest said that engaged in that issue, and the NGO's response was that we had misrepresented their protest and that they were not concerned with Yuba River conditions. It remains unclear to us whether the NGOs are actually attempting to deal with Yuba River conditions in this proceeding or not, given that we are not asking for any changes to Yuba River rules. We are simply petitioning for an extension of water transfer authorization. Thank you.
Fair enough, and I think it's helpful to, just in terms of thinking about what evidence you all are going to be needing to put on to understand, the bounds of the protest. So Mr. Schutz, at least with respect to the entity or entities that you may be representing in this proceeding, does that protest deal with Yuba River conditions, or is it just aimed at Delta conditions?
It only indirectly deals with the Yuba conditions. It deals primarily, the focus is Delta conditions and the storage of water during the spring, and the consequence that has in not releasing it in the Delta during the spring. So we're not seeking to challenge the entire construct of the Yuba Accord and the fisheries agreement in this proceeding.
Okay, thank you. I see Mr. Soderlund has raised his hand. So Mr. Soderlund, floor is yours.
Yeah, thank you. I just would like to, if I could clarify, and I understand we're at a pre-hearing conference level, but in going through your tentative ruling, I thought I heard you say that D1641 is fair game, maybe even impacts to exports, and so I don't know if it's fair to clarify, but obviously DWR's interest in this hearing goes way up if all of a sudden D1641 is actually on the table, or our permitted capacities are on the table, or the biological opinions are on the table, or is it just simply the impact of transferring water within those contexts?
The latter, Mr. Soderlund. I not only am I not interested in re-examining D1641 in this proceeding, I don't think I get to. So no, we will not be doing that. But to the extent that the protestants are saying, yeah, there are these protections from D1641 that Yuba Water is relying on, but they're not enough, and for the purposes of this petition, only additional conditions should be imposed. I think that's fair game. But no, we are not reopening D1641. Even if we wanted to, we couldn't do that. All right. I think that does it for the motions to cancel. As I said, I will make every effort to get a ruling letter out in the first week of June. If not that, certainly by the 11th, so that you have at least 2 weeks to adjust. But hopefully this gives everyone a reasonably good idea of where this is going. Mr. Sutherland, did you have more?
Sorry, one last. This is procedural. So we filed our request to become a party, and hopefully that gets followed up on. As far as identifying witnesses, would you like us to follow up with a supplemental NOI identifying a witness, or just submit by the later June deadline?
No, there's no need for witness lists in this. You will submit your testimony on the 25th. And that's your witness list, right? I don't need you to do it beforehand. I think we're generally trying to move away from that at the AHO, but I will know who your witnesses are when you submit testimony. So you need to do that. And I see that you did submit an NOI, and that's great. And then let me put a pin in the NOI issue. And Ms. Mendel-Rice, I'm going to get to you because I know you have a specific issue. So anyway, all right, ruling letter no later than the 11th, and then hopefully this will give you enough time. The tentative, at least, will give you enough time to make some adjustments as necessary. Although it is a tentative, and I could change my mind. But I have given all of this some thought. Okay. On other procedural issues, I have one other thing, which I see now that DWR and San Luis and Delta Mendota Water Authority and state contractors have all filed NOIs, which is good. And then Ms. Mendel-Rice, I think you also filed, in addition to the NOI, I don't know if it was styled as a request to appear pro hoc, but a request to appear, even though you are up in Washington State. So I will just ask, does anyone object to Ms. Rice appearing on behalf of the state water contractors in this proceeding? All right, hearing no objection, Ms. Rice, you are welcome to join us again as you have in several other proceedings. Did you have another issue you wanted to raise, or did I guess correctly that that was it?
You got corrected that that was the issue, and as Mr. Soderlund indicated, the state water contractors and DWR have both requested party status, and I anticipate that you will be addressing those requests as well.
Yes, and I will need to relook at my hearing notice, but I suspect those came in by the appropriate deadline to file an NOI, and I don't see any reason why you wouldn't be parties. So unless I see Mr. Bizzaro nodding, so I think I am on good ground to say you are parties, and we will make sure you're on our service list and identified accordingly.
Thank you.
Thank you. All right, any other procedural issues that the parties want to raise between now and the hearing?
Just one administrative issue. Does that mean that the state water contractors, DWR and San Luis and Delta, will be part of the meet and confer that discusses the length of testimony, length of amount of time allocated to each party, et cetera?
I would expect them to be.
Thank you.
Anyone else? All right, then with that, oh, I guess one other thing. Are you all planning to hire a court reporter for this proceeding? And I guess I'll look to you, Mr. Bizzaro, since it's usually the petitioner who ends up doing
Yes,
that.
I'm sorry, I interrupted you.
Yep, go ahead.
Yeah, I imagine Yuba will be retaining one for the hearing.
Great. Once we're closer to the hearing and you know who that will be, please just send an email to the AHO identifying who that is and a point of contact. I know the court reporters sometimes have basic procedural questions and stuff like that, and be good to make that connection. All right, with that, then we are adjourned. I think the next operative deadline is the submission of testimony on the 25th, and I will look forward to reading that in detail. And then, of course, you will get my ruling letter on the motions to cancel in the coming weeks. Thank you all very much for your time this morning, and we're adjourned.
Thank you.